So as we can see, the next presentation is entitled AI and the New Frontier of Medical Malpractice. This will be a joint presentation between Charles, for anyone who is not aware, who is our managing partner, and also Justin Monahan. And Justin is an associate at KMSC Law, and focuses on technology and liability, has published on AI and ethics, and they'll be discussing today exploring how AI is reshaping healthcare and malpractice law. So please welcome Justin and Charles.
Justin will join us shortly. Is this on? Oh, there we go. We could turn off that mic now. Yeah, back to talk to you about AI again. I think the more you hear about it, the more you realize it is actually coming. I thought we'd break down this presentation in a few ways. So I'm going to introduce some of the legal tools. Can you hear me okay? Okay, good. And thank you to Cynthia, who's here in the back. She's one of our articling students. She helped me with this cool, nifty type of presentation, not PowerPoint for the first time. I'm not using PowerPoint. So I'm going to just quickly talk about some of the tools we use in our office, and then I'm going to hand it to Justin, who is standing by on Zoom, and he's going to do a demo of the tools he uses. It's nice to have a partner at this AI stuff. I've worked with Justin at the Advocate Society AI presentations, and he does a great job demonstrating it. So I want to show you AI in action, how we use it to organize our cases, how we use it to ask questions for research, and how we use it to transcribe and prepare our cases. So it's a more practical application. And then when Justin is finished, I'm going to talk about part 2 and part 3 in terms of how it impacts the healthcare community and how it could affect future litigation. So that's kind of our future-looking part of the demo. Okay, before I get to Justin, I want to talk to you about one of the tools we use, which you've already heard about, FileVine. The AI tools that are in development and are working in the US but haven't come to Canada yet are, oh, it doesn't look like it came through, but we have something called Depot Copilot. Let's see if I can, that doesn't pop up. Which is a very cool junior lawyer type of assistant that comes on your cases. So imagine yourself doing your discovery, and you're going along with your questions, and then you take a break, and you usually turn to someone who's with you from your office and said, how did I do? What did I miss? This technology does that for you, and it's transcribing all of your questions and answers, so you can quickly review. You can actually give it some strategies ahead of time saying, I want to get an admission here, I want to get an admission there. And they'll tell you whether you actually got that admission or not. It's a pretty nifty tool, and that's called Depot Copilot. There's another feature called Medcron, which is a live chronology that you put all your documents into your document system. So we use FileVine to store our documents. It will constantly have a live medical summary going along, so you don't have to actually formulate it. It's always there. And then finally is Chat with Your Case, which is the idea of having this chat bot built into your case that you can ask questions about the case. So those features are in FileVine. And now we're going to see what Justin uses. He's going to demonstrate Harvey, Alexi, and Plaid. I do use Alexi and Plaid, and I've seen Harvey before. So I think right now I'm going to turn it to, if we can flip on the Zoom. There he is. There's Justin. Welcome, Justin. Can you hear me okay?
Yes. Can you hear me?
Yes. Sounds good. Okay. So I'm going to let you run the demo, and Justin has a similar practice. You do personal injury, and you put together demands, settlement proposals, mediation memos, pretrial memos, and we want to see your workflow because people are tired of hearing about my workflow. So this is going to be a fresh take on how other users, other lawyers use AI tools, and Justin is in Alberta.
Yes, good afternoon, everybody. I am Justin Monahan coming to you from Grand Prairie, Alberta. I'm sure when you walked in this morning, you thought you'd be hearing about AI from a guy up in the north, maybe in the middle of nowhere. So I'll do my best. What's interesting about this is Charles and I obviously have similar interests in this area in AI, but we have very different tech decks, so to speak. So the idea here is to give you a little idea of what other firms are using, what other lawyers are doing. So I like to keep it practical, focused on the practical. So without any further ado, I'll just show you some of the tools our firm is using and how we use them. And I'll share my screen here. Let me know if you can see that, Charles.
Yep, we've got it.
Perfect. Do you see RN here at the top? Do you see that?
Yes.
Perfect. Okay. Just wanted to make sure I was sharing the right monitor. So this is Harvey. Some of you may be familiar with Harvey. They're a very large legal startup. They have multiple different use cases depending on your practice area. Full disclosure, I do not do medical malpractice. I think maybe there's a little bit of a miscommunication there with the introduction, but I do a lot of personal injury, and it is very useful for medical chronologies, settlement demands, and so on. So this feature we're open to here, first of all, is the vault. You're able to make different vaults for your matters. So this one is for a client named RN, and I've uploaded all of her documents into here and organized them by different categories. So what you can do in the vault is you can just query, as Charles was talking about, kind of like having a chat bot. You can make any query of the file and see what it has to say. You can ask it about specific diagnoses, about chronologies, and so on. And then you can also create review tables. That's really what I'm going to show you all today. So I'll just click all of the medical records for now. And it's now generated a table with all of the medical records of the file. And then you can query it by column. So if you had a specific query, you could put it in here and save the table to your file once you're done. So today we'll ask, has there been any record of concussion-related symptoms for this patient? If so, when and what symptoms were reported? We'll just continue there, add the column, and we'll let it do its work. This is all live, so you'll see how long it takes. And you can do this with as many columns or queries as you'd like. Now, you obviously should be spot checking your AI, making sure the answers are accurate. Don't rely on it, fully without any kind of review. Charles is right. You should be looking at it as a assistant or a junior associate whose work you have to verify and ensure is accurate. So you can see here, of course, I did know this client has had concussion injuries, so I'm cheating a little bit there. But you can see there are records of concussion-related symptoms, and then what it's giving us, I'm sorry I can't make this any bigger for you all, but it has records in March 23rd, 2020 of post-concussion syndrome with headaches, memory issues, short-term memory issues, and disorientation, and so on. And if we were to go through here, there would be more and more of these different answers. And if it doesn't have an answer, then it comes up blank. And you can do different prompts, as I discussed before. You can make the prompts yes, no. So you only get a yes, no response. You can get a maybe response, which is always good because sometimes AI can lean yes when really it should be maybe. And you can, as I said, do this pretty much for any question you can think of. Now, Harvey obviously has more applicability than just the vault. It also has the ability for you to generate workflows. Now, these are some of our workflows that we've built in Harvey. They also have their own. Harvey just publishes with the application. So I've got workflows, draft an application for filing a consent judgment, medical record review, and then personal injury settlement proposal. I'll just give you a sense of what this looks. We won't be able to run one today. Oh, excuse me, I should go back here. I'm trying to get into my workflow builder, but I don't see it here today. That's odd. Sorry about that, but I guess I can just tell you that you can build your own workflows, and these workflows are basically a series of prompts. So what I've been able to do is draft this workflow such that it drafts a settlement demand, and it takes about 20 minutes of inputs. And then you have a 15 or 20-page settlement demand, reviewing all the medical records, reviewing all the relevant facts for general damages, how the client's symptoms are, how the symptoms have affected their life, and so on and so forth. Now, as Charles said, one of the good tools to couple with this is a plod note, which I'm holding here. And a plod note is just a device that records your conversation with your client, but then it uses AI to automatically transcribe the interview. So it creates a transcription you can save to the file, and you can couple that with your workflows and whatever system you're using to create better content. Obviously, an interview with notes is one thing, but an actual transcription of your hour-long interview with your client is going to be a lot better and have a lot more data to pull from. So I would highly recommend using that tool. I don't get paid for making these recommendations, by the way, but you just get a lot more. AI is only as good as the data you put into it, and you get a lot more usable data when you have that transcription of your interview. The last thing I want to show you in Harvey is the most basic function, which is assist. And this is just the basic tool probably everybody who has Harvey uses, and you can prompt it with anything you have. There's quite a few different forms of utility here, but I'm just going to show you one of the most basic ones, which is drafting an affidavit. So this is a prompt I've saved here for just our presentation today. And I've basically given it all the information it needs. So who I'm representing, what I'm doing. I'm asking it to draft an affidavit in support of a replevin application. I've asked it to draft expansively, so make sure it includes all the relevant details. And then I've given it a precedent, which I haven't uploaded here, but I did in the past. I've put in emails from the client, and then I've also told it what rule of court it should be referring to. And then, of course, if you had it, you could put in your transcript of your interview with your client, which would probably even result in a better product. Now, after doing all that, and then I think doing a bit of editing, this is what it came up with. And I'll zoom in here so you can see better. So it set out who my client is, what his role is, what his company does. And this is the most Albertan case I could show you probably. It's about a stolen, so to speak, horse liner that my client was trying to get back. And then some other facts and details relevant to their business relationship, the wrongful detention of the property, which is all set out here. And then this is what's required by the rules of court, the description and value of the property. So what he thinks each horse liner, saddle pads, all that stuff is worth. And then it just sets out the, why they're not entitled to the property. So that was all. Of course, that's not the raw product from Harvey. That probably took about half an hour, 45 minutes of editing maybe after it was done. But it did create a good first draft. And it was much faster than it would have been for me just to draft it from scratch. Moving on from Harvey, this is Alexi. So Charles can talk a bit about Alexi maybe because he's using it as well, but Alexi has a few different use cases. Maybe the biggest, most important thing for you guys is they're actually based in Toronto. So you could go meet with them in their offices if you wanted. So, and of course, all their servers are in Canada, of course, important for data security. But their biggest strength, I find, is in actual research. So different traditional legal tech platforms like Westlaw and Lexis, they've come out with their own AI. You've probably seen them. We've done cases of both. We've tried both Westlaw and Lexis. We found Alexi was better, which is kind of surprising because, it's just a startup. It hasn't been around for so long as those other companies. But they have a deal with Canley where they've got access to their database, and that's where all the results come from. So I just put a simple med mal question in here. Are apologies by clinicians admissible as admissions of liability in Alberta? And then locate case law and any statutes that may answer this question. And it took about 2 minutes or so. It's a little bit slower than some of the other platforms. And it came up with these answers. I found the Alberta Evidence Act provision, which was introduced in Bill 30, that says no apologies really are admissible. They're admissible so long as they admit facts, but not, or maybe not admissible as regards liability. Now, I do not do medical malpractice, as I said, so a lot of you will be either nodding or shaking your heads whether it's right or wrong, which is fair enough. But of course, the important thing is for you to verify this. So at least it gives you a place to start, look at the case law, review it, see if it's right, look at the statute, see if it's being interpreted correctly. Beyond that, they also have workflows. If you're looking for kind of a multiple utility from a platform, which probably we all are, they also have the ability to build chronologies for medical documents. So you can upload all your medical documents and it will upload a chronology. With these platforms, generally the less documents, the better the result you're going to get. So if you put in 50 documents, the chronology is not going to be as substantive as if you put in 5, especially if they're large documents. So keep that in mind. But we have had, use cases here every 3 months. We'll run a new chronology on the new medical documents we have to see quickly what the client has been up to in terms of treatment. So that is all of the use cases I had today. I don't know if you want to save questions till the end, Charles. If so, I'll just hand it back to you.
I have a question for you, if everyone can hear. So much of the success of your use of AI comes from your prompting and the ability to know how to prompt. And how are people doing, the people in your office, et cetera? You obviously have mastered it, but what advice do you have for newbies in terms of using this technology? I mean, it's not just with Harvey or Alexi. I mean, even if you were using ChatGPT or Perplexity, the better you prompt it, the better and more robust the answer is typically how it goes. And what is your suggestion on that front?
My suggestion is use the skills you have from instructing staff and associates, especially junior staff and associates. There's always the eternal gripe from junior associates where the lawyer on the lead on the file just sends them an email saying, take care of this. And sometimes a good associate will know what that means, especially with experience. But if they're very junior, they won't. So if you're able to instruct a junior quite well, then you should be able to prompt well, and that's the philosophy I would recommend. That's answer A. Answer B is some of these tools now help you prompt. So I just went back to Harvey here because I've got this prompt that I drafted. This is from an old case, probably 6 months old by now. They actually have an improve button. So you put in your prompt and you can click improve and it'll review your prompt and rewrite it in a way, that it thinks is better. Sometimes, or most of the time, it does produce something better. Sometimes I think it loses some things that I've asked or misinterprets some things I've asked. But, whether this is better or not, I'm not sure. I'd have to review it. But there are ways within the tools that will help you get better results. I can put in here, draft an email to Charles asking about how the presentation went today. And then I can ask it to improve it. And this is like a 10 word prompt. And we'll see here what it does with it. I imagine, draft a professional email to Charles inquiring. The email should be polite and concise, expressing genuine interest in the outcome of the presentation, include a friendly opening and closing. So, that's the kind of stuff it will improve. And I'm sure if you told it to draft an affidavit, it would also ask you, okay, what's the jurisdiction? What's the affidavit in support of, so on and so forth. And it'll kind of key you into the instructions you need to give.
I'll wait to see if the audience has any questions, but while we're waiting, Can you comment on whether, these specific tools are subscription-based? There are free tools, and then there are other subscription tools that are more broadly based, not just for the legal industry, like Microsoft Copilot. Can you comment as to whether you use any of those free tools or whether you use Microsoft or any other subscription-based tools that are non-legal?
The only subscription-based tool we use that is non-legal is Copilot, and we don't really use it for legal work. We use it for office management. So one of the partners here, he has his SharePoint environment where all of his management emails are saved in different subfolders, and he's able to use Copilot to quiz it. We don't use anything like ChatGPT. I mean, this might be redundant at this point, but I highly recommend not using those tools. They're not legal based in any way, and data security can also be an issue. And make sure the lawyers in your office know, no client data should be going into those models. The good thing about these tools is, you're able to vet the data usage. You're able to make sure your client's data is protected and so on and so forth. I believe Ontario is a PIPEDA jurisdiction, or maybe you have your own statute. I can't remember, but you got to make sure you're complying with that as regards your client's personal information. As regards to the payment structure models, it's generally based on per lawyer use, especially Harvey, but Alexi, they're able to actually roll it out to staff as well. So you can get some utility with staff use case as long as it's monitored properly. So you get more bang for your buck, by having more heads under your plan.
Great. I think Laura had a question first.
I do, yeah.
I'll repeat it. Yeah, unless you want to wait for the mic.
Check, check. Oh, there we go. My question is about the data security and the privacy. So the data that we have on our servers, I can answer the client's question quite specifically about what protections there are for their private data on our company servers. So for companies like Alexi, we can say their servers are in Toronto, but do they provide detailed information about the protections that they include on their servers?
I'll answer that question, Justin, because I do. In Ontario, the Law Society of Ontario requires all lawyers to keep their data in Canada. So anytime you use a legal software, you have to vet with them whether they have data centers in Canada. The Patriot Act in the U.S. allows the U.S. government to basically snoop in on any data. That's why we have that requirement. So Filevine has Amazon Web Service in Canada. They're SOC 2 compliant, which is also what you want to know. SOC 2 compliance is the highest level of hacking ability, and they have hackathons to challenge people to try to break in. And Alexi, similarly, it's not just Toronto-based, but it's Canadian. It's a Canadian company, and they'll guarantee that. Ploud, unfortunately, has not. Justin and I wrote to Ploud after our last presentation, and they cannot tell us when they'll have a Canadian data center. So if you're using Ploud, you use it the same way you'd use ChatGPT or Copilot. Very generic questions, nothing legal, nothing related to any privacy issues or a client related. And that's kind of the method when I talk about this. There's a closed system and an open system. So open means that they're training on your data. So when you go into these free systems, they're training on it. So you want to make sure that if it's an open system, that you're not putting in anything there that you wouldn't want coming back to bite you, right? You're basically just throwing it out there. And so you can ask those questions of the providers. And I always encourage having a relationship with the different software providers, trying to speak to the people who know all the answers, the security people. And most of these legal companies will have that answer for you, versus a closed system where the large language model is not learning off your data. And they will tell you your data will be stored for 90 days in a separate conversation, and it'll be automatically deleted, but it's only there for your convenience, and you can go in and delete it on your own. And Alexi says that to us. So I don't know if that answers your question completely, and I don't know if Justin has anything to add to that.
I would just add that if you have concerns about American companies like Plod, our policy is to get the transcription and then immediately delete it from their server, because they've assured us they don't keep copies. Once it's deleted, it's gone. The rules are different in Alberta as opposed to Ontario, so you'll have to take that with a grain of salt. But that's one way we mitigate risk.
Another question at that table.
Thank you, Justin. This is really interesting. Can you speak to how and how much of a cost saving is being transferred over to your clients now that you're using AI? How are they enjoying this lower bill?
Maybe
from
I
you?
can address that first, and then Justin, you can pick up the trailer on that. There's a question there too. So we do have a privacy policy. So the retainers in Ontario are standardized. You can't actually build it into the retainer, but we do a side letter where we tell our clients, and this is first of all not just for efficiency, but to tell them that their data will be used in AI systems. We tell them that we vetted those systems and that they're closed systems, they're secure, their privacy is secure. In terms of cost savings, we do believe that we are more efficient for the client. That efficiency means their case will be handled faster, but it also means that their case will be handled in a more efficient manner, that their case will go through in an efficient way. We can communicate with you in an efficient way, set up calls faster, put the case through faster. In terms of savings, wouldn't you want the case done quicker? Wouldn't that be more valuable to you as a client versus getting a discount? Because if the case takes 10 years versus 3 years, wouldn't you be happier with the lawyer that gets it through in 3 years? Wouldn't you actually want that versus an actual rebate? So, personal injury is mostly done on a contingency fee, and that allows more time for advocacy. So that's how I've told my staff that, in fact, we've tripled the size of our firm ever since going to Filevine, and I've told my staff all their jobs are safe. In fact, we're expanding because we're more efficient. We don't have to do mundane tasks. I mean, do you really want your lawyer typing and filing and doing labeling and things like that we used to do before we had some automation? So now the lawyer can spend time talking to the clients on the phone and advocating for them and drafting documents in a persuasive way with the first draft already done for them in an efficient way. So I believe these efficiencies bring a ton of value to clients, which, in a way, just makes the whole process more accessible. I don't know if you want to add anything to that.
I think you've covered a lot of it, Charles.
Okay.
I mean, it goes to the debate whenever there's a new legal tech solution introduced. Is it a way for lawyers to bill more quickly, or to pass savings on to the client? You're right. PI, personal injury, doesn't matter as much, because it's contingency. But I tend to take a middle of the road approach. I try, we get a little more value out of it, but the client saves as well. I think that's reasonable. The hard part is if the tools, if you pass all of the savings onto the client, it can decrease adoption, because lawyers are sitting there thinking, well, why should I bother adopting it if I'm just going to bill less hours or bill less in fees? I don't know the answer. It's something that the industry is going to have to wrestle with, but it's worth considering for every lawyer how they want to approach it.
One here.
So thanks for this, because I love AI. So with that plot that you were talking about, if we were to use that in an evaluation, would we need to indicate that in our report that this was, we use this during the evaluation? I mean, even if we're going to delete it, but could that be requested by defense, or what does that open doors for us?
So I think the question is, if an expert is relying on AI as a tool to draft their reports or come up with their conclusions, or
even assessments,
and that evidence is being used in court, what is going to be the disclosure requirements? And I'm part of the AI subcommittee for the Court of Appeal, and we're discussing rule changes. And so, yes, it has to be disclosed, is the answer right now. The rules haven't been approved yet in terms of the changes, but experts giving testimony using evidence that is partly AI generated will have to be able to explain their answers. So there is a case in the US, it was an estate claim where an accountant used software like Copilot to come up with the present value of the estate's value, came to testify about it, and the judge asked them to explain how you came up with your answer. Went back into Copilot, and it came up with a different calculation. So the court said, well, how do you explain the difference between what you filed in your report and what you did today? And he couldn't answer it. Threw out the report, threw out the expert. No, that's not reliable. It's not informative to the court. It's not explainable. So that's the kind of test that it's a rules of evidence, right? So if those rules of evidence can't be followed with whatever tool you're using, then it's probably not going to be allowed, is the way it's going to work.
So if we were doing, say, if we're doing a document summary, do we still need to disclose that from a AI document summary? I'm using something similar to Filevine.
Right. So, I mean, if we use a word processor, most people don't challenge how your word processor did spell check or things like that. Those kinds of efficiencies, I don't expect there to be a problem. But if you're trying to come up with the ultimate question answered in your tools, then those are the things that are going to be on the mind of the judge and testing the reliability and explainability of the data. And usually the solution is, where's the human in the loop in that technology? And so most of these solutions that Justin and I are talking about, you still have to go through and do your own fact checking and do your own case law checking, because we've seen tons of examples where the cases are fictitious because you're using a bot that's creating content because it's set to be creative. ChatGPT is not a legal solution, it's a creative solution. It's coming up with a fictional story about a case that you asked about. Whereas some of these products that we've subscribed to are pulling it from databases, but even they can make mistakes. So you have to be able to check them. Okay, I guess we'll just do this as the presentation. I won't do my part. Okay. Yep, go ahead.
My question was, in a practical sense right now, what has changed within your practice? Like, do you no longer go through file first by yourself? Or maybe like normally you would have had a clerk do it, but there's always things that when you go through as a professional, you pull out and go, oh, that, I got to follow a trail on that. That wasn't sort of part of the broad summary I was given or how I understood it to be. So do you still, like in a practical way, how has this changed, I guess, how you guys
so
operate?
It's a workflow question, and great question. And I love that question. That's what I talk about mostly, is how it's affecting our workflow. And I would think of AI as, who am I delegating work to, and can it be done through an assisted, system? Otherwise, the workflow is exactly the same. Everything you do to approach a case is the same. It's just, can you use AI to help speed up research on a topic? Can it speed up review of a document? Doesn't mean there's no human that's going to do it, but now we have a product that we can scrutinize and build on. So it starts like my workflow, intake, right? Calls come in. Jan talked about our 1% acceptance rate. It's hard to filter through all these calls. AI helps us triage the case to filter which calls get returned faster. Then we take in the calls. AI helps summarize some of the records and enter it into our data fields. And then some of the letters can be populated for the lawyer to review, instead of typing the same letter over and over again, which we used to do. And then as it goes through, maybe you have to research a nuance before you can decide to start the lawsuit. You could ask Alexi that question. Alexi does a great job at quick answers to research questions. And then as you go through, obviously it becomes more advocacy, but there's certain mundane tasks that can be delegated. And that's really how I think about it. The workflow hasn't changed. It's just now we can delegate some of these tasks to AI. Oh, Richard was also waiting in the background. I had some slides to talk about some of these questions, but now I will fly through them.
I just want to add.
Now? Okay, perfect. I just want to add to one of the things that was just asked about experts' use of some of this technology. I absolutely think it needs to be disclosed, because as the lawyer on the file, I also can help you, as my experts, and I know there are providers in the room, know what level of reliance would be appropriate and what is not. And the last thing I want is to find out later down the road that there's been some reliance on an AI tool, because Charles mentioned a minute ago about the courts changing. I was just involved in a review that the Trial Lawyers of Ontario was asked to consult on for a change in rules. And one of the things that was being proposed and talked about is any expert that in any way relies upon any tool that has AI, including it could go so far as dictation software, knowing about data sets and how these tools were trained. Well, that goes far beyond what most of my experts know about the AI tools they're using, and it's a problem. And so if we don't have the opportunity to have that conversation with our experts, whatever expert they may be, Pinta recently had a situation with an expert using it to review literature, and without putting eyes on every single page of the literature that was reviewed and relying upon a summary. That is incredibly problematic and can result in an expert actually that we cannot rely upon them anymore and have to start over. That's very concerning to me, and it would be a disaster at trial. So these are the kinds of things that we want our experts to have a conversation. So if you are using those tools, let us know so we can have an open conversation about what use is appropriate, what is not, because there could easily be some serious issues with that.
And my suggestion is it's not no, don't use them, just double check the work. So you can talk to the lawyer and say, I use this technology, but I've now double checked the work, and I'm comfortable that these citations are accurate. You know, that's what's expected. Don't use it as a shortcut.
Charles, I've got a basic question. Does AI, and anybody in this room will know, look at the color of my hair, you'll know I have no idea what I'm talking about. Does AI read handwritten stuff, police officers' notes, medical records? Because I get a ton of that, and I can't read it. Does it do that, and to what extent can we rely on it?
If you don't mind, Charles, I'll answer that. So
go ahead.
if you can't read it, then it can't read it. You know, if it's not readable, it's not readable. If it is readable, then some platforms, I think most these days, can read them.
And the other, so we have another solution. We're using sort of an engineer. He's in this room, and he was helping us on putting together spreadsheets that Richard likes to use to distill all the data. And what they've done is where they come across perhaps illegible handwriting, they'll take a guess at it, but they'll put a red note next to that site to say, you better double check this. So it's sort of like color codes what it's confident with versus not confident with in terms of how it created that chart for you. That may be useful. It may speed up your review. I mean, you got thousands of pages of documents and only maybe 100 handwritten. You're still better off with that solution, knowing what you have to double check than the alternative. Okay, well, good discussion. Oh, one more.
Pardon me, I have a bit of a cold. I was saying something that Jan said. There are 23 colleges for health professionals. And I don't know, I've been in the practice for some time, and I don't know what my college would say. I have ideas. However, so when you say that something about the professionals or the experts, I would assume that they would be part of one of the 23 colleges. And what I know is that none of them have made AI part of the discussion whereby what is acceptable. Now, we also know that in the health field, things don't happen quickly. So it's not really a question. It's just kind of bringing up a topic.
The advice to give you is that there are Law Society guidelines in each province that tell the profession how to use AI carefully and comply with your privacy, et cetera, and how it's to be used, as well as court guidelines about what experts can expect when it goes to court. And if you're familiar with that and you're using these reports for medical legal purposes, you should familiarize yourself with those rules. They're available if you search up AI Ontario court rules, you'll see that there are guidelines. There's also Law Society guidelines for lawyers, so that we know that we're not violating confidentiality when we're using AI tools. So in each province has it. Alberta has their own. And so that would be a way, my suggestion, while you're waiting for your college to come out with a policy,
Right.
and if you're working with lawyers, at least comply with those policies.
Right, but it wouldn't be complying with my college, which the report could be scrutinized, and so it would become a problem, from what I
If
think.
your college has no policy, then I don't know how it would be, what would it be scrutinized by?
Well, the question would be, why are you using, there's no best practice that allows you to use AI.
Yeah.
Um,
I mean, these tools are going to be generally
Of
accepted like a word
course.
processor.
So in the meantime, use your approach, okay?
Pinta has a better answer.
Well, I would say that physicians are already using AI for prescriptions in some ways. It is happening already, as Jan indicated. I've had that issue come up with experts. I now, in the retainer letter, have drafted a rider specifically saying, if you are using AI in any capacity, you need to let me know. We need to talk about what it means, so that we can at least have that discussion, right? To Jan's point, I don't want to be kept in the dark about what you guys are using. I do have a question, though, with all of these transcription programs that we're using, because it's come up when I'm dealing with other lawyers, because our law society, you cannot record another lawyer without their express permission, but a lot of the times these programs automatically start the recording. And I've had defense counsel get upset, like, oh, you're recording. What? I'm like, just say no if you don't want to be recorded. But how are you dealing with that? Do you let them know at the outset, or you just?
Yeah, it's a good question. So we use Zoom as our preferred voice over internet phone, not just as a video platform like Justin's on right now, but and you'll see, actually he's on the web version, but I think there's usually a flashing thing that says AI assistant at the bottom. And if you're on the phone version, it'll say this is being recorded. And if it's on the video one, you actually have to say okay, so you're consenting. So there is notice during that type of software. Cloud, I always tell them if I'm using it. The Copilot, Deep Depot Copilot software that I talked about, I have not been able to use it. It is great. I've seen it demoed and I want to use it. I've tried to use it. Opposing counsel has never agreed to it, and the transcription service has never agreed to it. But I've tried to ask for permission to use it, and what I expect will happen over time, because I'm sitting with a lot of judges and they want to use these products too, especially for transcription. They need it, right? I mean, they're writing these decisions and they want it faster, right? The transcription, the court reporters can't keep up with the work demand, right? So, and they want it in real time, and they want it summarized, and they want all these tools available. And they're allowed to get, in certain situations, a memo to court. So they are using recording devices on their own. And they would love us to be able to be better advocates for our clients. I mean, they're encouraging the use of AI as long as it's not misused. Don't cite case law that doesn't exist, but use it to better the representation that you're doing. So if this means you're a sole practitioner and now you have an associate that can sit with you and help you present better and catch the flaws of your argument so you can fix it before your submissions are over, why wouldn't a court want that? So I think what's going to happen is it's going to be in reverse. The courts are going to make some rules allowing it, and these transcription companies are going to have to start allowing it. Now, we're not taking away their business. These transcription products that I'm talking about are actually just there to help us advocate. They're not there to steal the transcript and say we don't need you anymore. We still need a court reporter to sit through the process. So I don't know why they're so resistant. I think they're just not sure what it is. And I think eventually it'll be permissible. Okay, another question, AI question.
Hello? Yeah. So we did just have a webinar on this yesterday, and basically the position of the College of Physiotherapists of Ontario is that they don't care if you use AI scribe software or AI for anything else. Whatever it produces, it's just your responsibility to check that over. If it comes up with something that is inaccurate or whatever, that's on you. So whether you're using it as like a word processing software, it's still the responsibility of the physiotherapist to check that. But it is absolutely okay to use.
Are we done? Am I out of time? Okay. Thanks so much, Justin. I didn't get to the future. You'll have to stay tuned for my next webinar. Thanks, everyone.
Thank you.